Good morning, everyone. Thanks so much for joining us today for our second presentation in the Employment Law in Financial Services series of webinars. As you'll know if you were here last week, these are bite-sized introductions to employment law considerations specific to regulated financial services businesses throughout the life cycle of an employee. Today, we'll be focusing on training and culture aspects of a regulated business once a successful candidate has joined a regulated firm, including the need for regular training and assessments of fitness and propriety, as well as overall firm culture as well. So my name is Jamie Meechan. I'm a senior associate in the employment law team here at Burness Paull, and I'm joined today by Lorna Stephen, who is an associate in the financial services regulatory team. As always, just a little bit of housekeeping before we get into the swing of things. Please keep your cameras and microphones off during the presentation. Just to say also that we'll be recording today's session and we'll send out a copy after the webinar today. Given the length of time that we've got, we may not have time for questions today, but our contact details will be on the final slide. So please do get in touch with us after the webinar if there's anything you'd like to ask or discuss. Similarly, feel free to pop questions in the chat, and if we don't get time to answer them, we will come back to you after the webinar. Moving on to the agenda then, and following on from last week's session where we looked at considerations during the recruitment phase and making the offer of employment, today we're going to fast forward a bit to look at the employment and financial services considerations once an employee is in post, once they are in employment with the financial services firm. We'll start by looking at fitness and propriety in more detail. We'll then look at statements of responsibility before going on to consider whistleblowing and overall firm culture. And with that, I will pass over to Lorna to discuss some of the financial services considerations first.
Thanks very much, Jamie. So we briefly mentioned fitness and propriety last week if you dialed in, so you might be surprised to see it again so soon. But we discussed in last week's session the need to assess prospective candidates' fitness and propriety at the application stage, so when they were joining a business, and that the regulators would also complete a similar assessment on receipt of that application. However, fitness and propriety is not a once and done requirement, and regulated firms are required to undertake continual assessments to ensure that an individual remains fit and proper during the course of their employment with the firm. The firm may also have to carry out an out-of-cycle or an ad hoc fitness and propriety assessment where an individual is subject to disciplinary proceedings or any other serious event. And if you didn't manage to join in with this session last week, just as a reminder, the fitness and propriety requirements centre around honesty, integrity and reputation, competence and capability, and financial soundness. And in assessing fitness and propriety, the FCA will take account of the activities that a firm for which the controlled function is or is to be performed, and the permissions held by that firm and the market within which it operates. So we'll look at each of these in a bit more detail today. So the first one is honesty, integrity, and reputation. And it's a slightly abstract concept, but the FCA has set out some things that it would consider, and those are set out in the FIT section of the FCA handbook. Now, FIT is short for the Fit and Proper Test for Employees and Senior Personnel, part of the FCA handbook, but usually most people just refer to it as FIT because that's a lot shorter. So the FCA, and therefore any firms assessing fitness and propriety, will have to consider whether the person has been convicted of any criminal offence, and there's particular emphasis on the criteria here, where the crime is one of dishonesty, fraud, financial crime, or insider dealing. Another point is whether the person has been subject to any adverse finding or any settlement in civil proceedings, and again, that has quite a large focus where it is in relation to investment misconduct, fraud, or the management of a company. whether the person has been dismissed or asked to resign from employment or has been disqualified from acting as a director. So that might be where their ability to act in that role has come into question, and whether the person has been subject of any justified complaint relating to regulated activities in the past. Now, these items are just a subset of the things that the FCA will look at, and the full list can be found in FIT if you're keen to go look that up after the session. But generally, the considerations specified look at whether the individual has been found guilty of anything which might compromise their ability to perform a senior manager or other function in an appropriate way. And you'll see as I've been going through that list, there's a particular focus on dishonesty offences and fraud, and that reflects that people with power in financial services businesses have the potential to cause quite a lot of harm to the market and consumers if they were to be acting in a dishonest way. And it's that point that makes this so important, that the FCA and firms ensure that those people who have that ability, that influence to act in that capacity, are doing it in a proper way. So the next criteria under fitness and propriety, as we mentioned last week, was competence and capability. So under SM&CR, ongoing training for senior managers is essential to ensure they remain competent, comply with regulatory requirements, and uphold the high standards of conduct as required by the conduct rules. Training is an important aspect of maintaining a robust governance framework and fostering a culture of accountability within a regulated business. The FCA advises firms to have regard to the following factors when assessing competence and capability of an individual: whether the person satisfies the relevant FCA training and competence requirements in relation to the controlled function that person performs or is intended to perform at the application stage, whether the person has demonstrated by experience and training that they are suitable or will be suitable if approved to perform the controlled function, and whether the person has adequate time to perform the controlled function and meet the responsibilities associated with it. Now, the guidelines I've just given you there are the ones for the senior managers, and there are more general requirements which are worded slightly differently, but they do amount to a pretty similar thing on that point. So the firm must review employee competence and training needs regularly, taking into account changes in the marketplace and products, regulation, and legislation. The firm must also consider the skills, expertise, technical knowledge, and behaviour of its employees in practice. There are a number of areas which firms could consider to be relevant to their employees for the purposes of the competence and training aspect, and these can include refresher training on the conduct rules themselves. So all employees must be familiar with the conduct rules, as well as senior managers being familiar with those additional senior manager conduct rules that we mentioned last week, and what this means in the context of their day-to-day jobs. Ultimately, relevant staff should know what a conduct breach looks like in the context of their own role that they perform on a day-to-day basis. There's regulatory knowledge and updates. So senior managers should be aware of regulatory changes and industry best practice changes, which could impact the way that they have been carrying out their role, might make them change what they do going forward. Risk management and compliance, so identifying potential risk in their organisation and any strategies to mitigate this. And finally, financial crime and anti-bribery and corruption, so reinforcing knowledge of employees on the different types of financial crime which are evolving as these get more sophisticated, and any corruption. They also expect managers to be adequately trained in the firm's approach to fitness and propriety, and that the relevant SMFs oversee the process and ensure appropriate reporting. The FCA's view is that generally training delivered locally by line managers or other personnel is more effective in increasing understanding, as e-learning modules or generic presentations can be less effective in engaging the audience. Good training should be interactive and based on realistic and challenging scenarios. Now, financial soundness is the final criteria that we've got under the fitness and propriety test. And the FCA's key focus in respect of this limb is whether the individual has been subject of any judgment, debt, or award that remains outstanding or wasn't satisfied within a reasonable period, and whether the individual has made an arrangement with their creditors or otherwise having been subject to bankruptcy or similar. Note that both of these criteria relate to the judgment of bankruptcy occurring in the UK, but also elsewhere. So it's not a defence to say that the debt or bankruptcy took place overseas. That remains relevant to the FCA's and the firm's assessment of financial soundness of an individual. Unless there is any concern from the FCA with regard to an individual's financial situation, the FCA doesn't require a candidate's application stage to submit a statement of assets or liabilities, but it would expect to know about anything which might come under those headings of any judgment or debts outstanding. It's also important to note that remaining fit and proper by being honest, capable, and financially sound is the responsibility of both the individual and the employer. The individual must ensure that they notify the firm of any change in circumstance which might affect their fit and proper status, and the firm in turn must consider whether it's necessary to inform the FCA of any change. So just like the fitness and propriety assessments not being a one and done, firms and senior managers must ensure that their statements of responsibility are also up to date. So for anyone who didn't make it along to the last session, the purpose of a statement of responsibility is to make clear what a senior manager is responsible and accountable for. It should be clear and easy for the regulators, the senior manager, and others in the firm to understand that statement of responsibility and how it fits in with any of the other ones. It should also contain enough information to clearly describe the actual responsibilities and accountabilities, but without unnecessary detail. It's also important to remember that it's not the same as a job profile, so it shouldn't include competencies and skills required for the role or how these should be discharged. Instead, focus on what the senior manager is accountable for. Preparing and maintaining an up-to-date statement of responsibilities is a legal requirement and requires that if there's been any significant change in the responsibilities of a senior manager since applying for authorization, a revised statement of responsibilities must be provided to the regulator. And where you are applying to the regulator and saying that the statement of responsibilities has changed, they may ask for further information in support of this change, just to understand, have these responsibilities been given to another individual in the business? Does this reflect a change in the way the business is operating? So they will likely ask questions and just want to understand what's kind of driving that. And so the key important point to take away here with statements of responsibility is that they must be kept up to date and accurately reflect the responsibilities of the senior manager at all points in their employment, not just when they're kind of brought in, hired by the firm. It's really important that is up to date and it's an accurate reflection of the position on a day-to-day basis, so that if the regulators need to understand who is responsible for a certain decision being taken, they can refer to the statement of responsibilities and say, right, this is the person who has responsibility for this area, and this is who we will speak to about it. So with that, I will hand you back to Jamie.
Thanks, Lorna. And I think just before I go on to speak about whistleblowing and overall firm culture, just some observations from an employment law perspective on what Lorna has been speaking about there. And thinking about fitness and propriety in particular from an employment law perspective and during employment, there should be a contractual requirement that employees are and remain fit and proper, as well as a contractual obligation that they disclose promptly to the employer any matters which might affect their ongoing fitness and propriety. So that's something to make sure that you've got in employment contracts and that's made clear to employees. Employees should also be made aware that an individual's private life can be relevant to an assessment of fitness and propriety, unlike the conduct rules, which are more concerned with conduct at work. And these points can be made to staff during staff training, for example. Employers can also and often do incorporate the annual fitness and propriety assessment into their annual appraisal and kind of performance management processes. But as Lorna said, that's not the end of it from an employment perspective, as it's an ongoing assessment, and there can be events during the year which trigger a fitness and propriety review. So, for example, disciplinary action, performance and capability issues, potentially even grievances as well. So, um, at those points, the employer would have to consider the impact it might have on fitness and propriety. And so employers should consider building all of this into their HR processes in this sector. Some employers will have a separate conduct panel or a fitness and propriety panel whose role it is to look at these matters through a regulatory lens, and sometimes separately to, for example, the manager dealing with a disciplinary allegation through an employment or employment, a kind of employment law or HR lens. Um, I would say it will vary from firm to firm and often depends on the firm's size and resources. But in any event and in all cases, every firm must consider the regulatory regime, including the conduct rules and fitness and propriety, when following any relevant HR processes. Moving on then to look at whistleblowing in this sector. I think it's fair to say there's a recognition that the employment law regime for whistleblowing is only effective to a certain extent in actually encouraging people to come forward and raise concerns. All the employment law regime really does is protect people from detriment and dismissal, but it can be quite difficult for employees to make out those claims. And I don't think that does enough in and of itself to encourage that psychological safety in a culture where employees feel that they can speak up and raise concerns about wrongdoing in the workplace. And so we've seen, particularly post-financial crash, that there has been a real focus from the regulators on ensuring firms put in place adequate processes and mechanisms for those who do blow the whistle. And by that, we just mean raising concerns about wrongdoing in the workplace, sometimes referred to as protected disclosures in the employment law world. And that's whether those disclosures are internally or indeed directly to the regulator. There's a whistleblowing section in the FCA handbook, which is well worth a look if you're an employment lawyer or working in HR in this sector. I suppose what we've got now is a series of rules requiring firms to do certain things. You'll see some of them listed on the slide there, but it includes things like a requirement to implement appropriate and effective internal arrangements for handling whistleblowing complaints. The more channels by which staff can blow the whistle, the better. Some employers will include anonymous reporting mechanisms as well. There's also a requirement to have a whistleblowing champion, and that's usually someone at board level, and also to ensure that settlement agreements expressly state that workers have the right to make protected disclosures, notwithstanding the confidentiality and other terms in the settlement agreement, which I would say, a well-drafted settlement agreement should include anyway. So always worth checking whistleblowing policies to make sure they are fit for purpose in this sector, but also for your particular organisation, and not just off-the-shelf type policies which have been kind of taken off the shelf and implemented without little thought. So it's worth really spending a bit of time making sure that your processes and procedures are in good shape here. And then moving on, and just the kind of final thing that we wanted to focus on today is just spending a bit of time talking about overall firm culture and diversity, equity, and inclusion, which is a real kind of interest area of mine more generally. So always happy to talk to people about DE&I, so please do reach out offline if you're interested in that area too. But for today's purposes, I suppose this is something that us employment lawyers have always been telling clients to take seriously, but we're also now seeing the regulators taking it more seriously too. So kind of more important than ever in this sector. DEI is as an umbrella term encompassing a wide range of issues really, so including discrimination, equality law, environmental, social and governance, ESG factors, and equal opportunities. So all of which is lending itself to creating a diverse and inclusive workplace culture. DEI is a key focus for the UK financial services regulators because they regard it as a regulatory issue. They see it as a vital part of a firm's culture and how a firm manages its risks and serves its customers. A lack of diversity could result in groupthink at decision-making levels, which could in turn lead to consumer and market harm. The regulators believe that a more diverse and inclusive financial services sector will result in improved governance, decision-making and risk management in firms, as well as a more innovative industry providing products and services that are better suited to the diverse needs of consumers. Just on this, the regulators recently consulted in proposals to introduce a new regulatory framework on D&I in the sector, including collecting, reporting and disclosing certain diversity and inclusion data, which some firms will already be familiar with to some extent if they're caught by, for example, the gender pay gap regulations and are used to annually reporting on that. The outcomes of and proposals from the consultations are awaited, and we'll keep you updated on that. So do make sure you're signed up to receive our updates for both financial services and employment law. But of course, there are lots of things that employers can be doing to improve DEI in their firms meantime, including providing training, organising education and awareness raising sessions, reviewing and updating policies, carrying out risk assessments, conducting monitoring and staff survey type exercises, and lots of other things too. So again, do get in touch with us if you'd like to discuss any of that in more detail. It's also worth just noting as well that there's a new piece of employment legislation expected to come into force later this year, which will introduce a new duty on employers to take reasonable steps to prevent sexual harassment in the workplace. And we're advising a number of clients on steps which they can take now with a view to this duty coming into force later in the year. And updated technical guidance from the Equality and Human Rights Commission is expected before the law comes into force, with further details, including what the EHRC suggests that employers should be doing to comply with this duty. So again, something to look out for in the coming months. And this is a positive duty, so it's a duty which employers will have to comply with. And if they don't, then claimants in the tribunal can apply for an uplift to any compensation which is awarded. So that can be contrasted to a duty which some of you in the call will already be familiar with, or not a duty rather, but rather a defence to other types of discrimination and harassment claims where the employer can show it took all reasonable steps to prevent discrimination and harassment. So we've already got that kind of defence which is available, but actually the law is going a step further now, and will be introducing a positive duty on employers to show that it took reasonable steps to prevent sexual harassment. I would say that we often become involved when clients are responding to discrimination and harassment allegations, whether that be internally or through the employment tribunal system, but we can also get involved in the preventative rather than reactive measures. So I suppose the kind of takeaway from this part of the presentation is really just to watch this space, because there's lots coming down the track, and also do get in touch if there's anything that we can help with here, whether it's providing staff with or managers with training, or kind of reviewing and updating relevant policies, or anything else. And with that, I will pass you back to Lorna to close today's webinar.
So thanks very much, Jamie. So rounding up today's webinar, we've looked at some of the ongoing requirements around fitness and propriety, and the need to make sure that statements of responsibility for senior managers are kept up to date at all points during employment. And I mean, I'll bang on about this until the cows come home, but it's very important to make sure that these are refreshed on an ongoing basis, and these are not just once and done obligations. Jamie has also given us some great information on the importance of whistleblowing and having a culture which facilitates effective whistleblowing, as well as wider considerations of DEI in all firms. And I think what Jamie said about the changes coming down the track in this space is really interesting. So really looking forward to seeing what comes out of that later this year. So that brings us to the end of what we're looking to cover today. So thank you very much for dialing in. Really appreciate it. It'd be great if you could join us next week as we turn to look at misconduct in a regulated context. So we'll close the webinar there and hope everyone has a fantastic Tuesday. Thanks very much.